All right. Well, I see 1:30 on my clock, so we'll move along. Just before we get started here, a couple introduction pieces. Again, welcome everybody. You're joining us. My name is Eric Hauge. I'm the Executive Director of Homeline, and you're joining us on Wednesday, August 18th at 1:30 in the afternoon for another 90-minute webinar on Minnesota's eviction moratorium phase out. And today, again, 90 minutes, 1:30 to 3. Today we're joined by, along with myself and Rachel Sterling, Homeline's COVID-19 Eviction Response Coordinator and Housing Attorney. We're joined by Larry McDonough, who is a Senior Minnesota Fellow with the Lawyers Committee for Civil Rights Under Law. We're going to get to Larry in just a moment with his presentation. But before we do that, just a couple pieces of information. Again, just a quick reminder, today we are applying for Minnesota Continuing Legal Education or CLE credits, 1.5 credits for this session. We'll apply after the fact and notify participants once that's approved. And with that, I'll have Larry, if you want to start moving forward on the slides. Just a reminder about what Homeline is. We are a statewide nonprofit organization. Our main program is a free and confidential hotline for renters throughout the state. We've advised over 265,000 renters since opening. And our services are available to folks in English, Spanish, Somali, and Hmong languages. And you know what? I didn't update this slide because we have a bigger staff now. I think we have a staff of 23 or 24 now. We are growing. There's our hotline contact information, and as well as direct language lines for folks who need language support in English, or sorry, Spanish, Somali, or Hmong languages. You can also email an attorney on our website. And then we have a variety of resources on our website. If you want to move it forward again, Larry, a phase out FAQ, we've shared that in the past. I'll put these links in the chat. The schedule for our upcoming webinars and recordings of all our previous webinars, including the last few where we've had some really excellent guest speakers. And we'll have today's session up on the website at that link soon. So before we get started here, just a couple items on our upcoming webinars. So we have just a couple scheduled next week. We are going to be joined by Catherine Kelly, who's Assistant Attorney General. And if you'll recall from earlier during the pandemic, the governor's executive order that suspended evictions was tied to the Attorney General's office was sort of the key enforcer of that order. And so Assistant Attorney General Catherine Kelly is going to be joining us and talking a little bit about what was involved with their office enforcing the order. They are no longer directly called out as a agency that is directly enforcing the eviction moratorium phase out. But Assistant Attorney General Kelly will share a little bit about what they're doing going forward, and we'll be applying for CLE credits for that session as well next Wednesday, again from 1:30 to 3, 90-minute session. We're taking the 1st of September off. It's a very busy time for Homeline on our hotline around the beginning of the month. But then we're circling back on the 8th of September, Wednesday the 8th, and a little bit different session on the 8th. It's going to be in the evening. The focus is really to have it targeted for folks who need assistance and help and information about the key aspects of the phase out. So it is specifically targeted for an audience of tenants and advocates, organizers, service providers that work with tenants and other individuals that are sort of talking to or working with renters on a regular basis that want to learn more about the details of the phase out. We are going to be offering simultaneous interpretation in Spanish, Somali, and Hmong languages through the Zoom platform. So you'll be able to join and listen in on the audio feed that you prefer for the language you prefer. And we're not requiring registration for that one. I will post links to how you can sign up for a reminder and how you can join that one on the 8th. Yeah, and as always, we continually want to remind attendees of our webinars and folks that contact us over a hotline of the two key rental assistance programs, renthelpmn.org, or dialing 211 for more information about Rent Help MN. This is one of the key programs that is called out specifically in the Minnesota's eviction phase-out law as one of the programs that protects you if you have a pending application from eviction for non-payment. So it's critically important for people to apply there. And the other one is the Zero Balance Project, which is at Housing Link's website. Again, that one is limited to Dakota, Hennepin, and Ramsey counties. And it is a landlord initiated program versus how Rent Help MN works, where the tenant initiates the program. And if you're interested in more information about kind of the interplay between the Rent Help MN, Zero Balance Project, and the phase out law and just general overviews of those programs, we did have guest speakers in July and early August from both of those programs on our webinar, and I'll share the link to those in the chat in just a minute. You've listened to me blather on for long enough, so I'm going to pass it over to Rachel to just provide a very quick overview of where we're at on the eviction phase out timeline, and then we'll get to Larry and the real meat of today's presentation.
Thanks, Eric. So yeah, just briefly, we've been going over kind of the moratorium phase out stuff throughout our presentations this summer. So we're going to cut out most of the stuff that we normally do, because Larry will do a much better job about covering that in a minute. But for those of you who, like me, are a visual person and like to see what it is that we are currently in for phases, we have, as of last Friday, just entered into phase 3. Phase 3 specifically is about landlords being able to terminate and not renew leases for tenants who are behind on rent who are not eligible for any of those COVID-19 emergency rental assistance programs. So all the stuff that we've talked about before through phase 1 and phase 2 still in play. And now this is a new phase in for, again, just terminations and non-renewals. So this is the timeline that you can find on the website in our facts page. If, again, like me, you are a visual person and you appreciate the boxes to tell you where we are, but you can also see where we are going. So without further ado, I will introduce Larry. So Laurence McDonough, or Larry, as we generally refer to him, is the Senior Minnesota Fellow for the Lawyers Committee for Civil Rights Under Law. And he's been working in various aspects of housing law for decades. He's literally written the book on housing law here in Minnesota. So really pleased to be able to have him join us today and kind of share some of that knowledge with us on specifically focusing on evictions, especially in the time that we are and how those are impacted by the current session law like this phase out. So without further ado, Larry, the field is yours. Except you're on mute.
Okay, thanks. I'm gonna stop sharing just for a moment and just talk to people a little bit. So what we're going to focus on today is very specifically on eviction cases and how they are affected by the, I like to call it the transition law. I'm not that a big fan of the off-ramp or the phase out. So anyway, so I'm going to focus on that. And for those of you that aren't attorneys, some of it might seem a little bit technical, but I still think it's important for attorneys and non-attorneys, landlords and tenants and advocates and the like, to really understand how these laws specifically affect eviction cases. And I want to make the distinction between lease terminations and evictions. So as Rachel was just mentioning, we just had an opening. So I think I will go back to the slideshow now. So let me just take a second here to get back to it. Okay.
And while Larry's doing that, I'm just going to mention, because I forgot to say it, we did, there will be some time, I think, at the end for questions, right, Larry?
I'm really fine with questions throughout. I can time this okay. So if there are questions that come up, if it turns out they're on topics that I'm going to cover shortly, I might punt on them for a few minutes. So I might wait on questions until we dig a little bit into it, but then feel free to throw them at me.
Sounds good. We have a handful that got submitted in advance and we see a couple in already, but yeah, I guess what Larry says is feel free to submit. We prefer if you can send your question over the Zoom Q&A question and answer thing because it's much easier to track. Thank you.
Yeah. Okay, so I've got the slide back up here of the phase out timeline that Homeline put together. And so just look at phase 3 and phase 4, because this will help me kind of reinforce the distinction. What opened up in phase 3 is the ability of landlords to terminate leases or not renew them if the tenant's behind on the rent and ineligible for emergency rental assistance. But those landlords can't evict tenants through the court system until we get to phase 4 for that reason. And too often, I think the words eviction and termination get kind of bandied about as being kind of similar to each other. And in common language, they are. You know, when people talk about eviction notices, they're usually not talking about court summons. But I really want you to remember that distinction as I discuss what kinds of eviction cases can be filed now and as we get through the phases down the road. Okay, so let's move ahead. So this is the title of my training, and here's my information. Feel free to email me afterwards if we don't have time to get to your questions today. Part of my job with the Lawyers Committee is to help answer people's questions. So I have a bio there, but you know, of course, it's a pack of lies, so don't read that unless you want some humor with it. This is a seminar that I've been fine-tuning. I started giving it on July 15th. I did a lot of seminars in the last year, including ones with Homeline under the eviction moratorium that we had in place now. These are ones that I've been doing since the transition law went into effect. Okay, so what I'm going to talk to you about today are resources, talk a little bit about the transition law and the CDC order, which is in the news a bit. It doesn't have a lot of impact on Minnesota, but I thought I ought to let you know what I think about it. Talk a little bit about how evictions work, and then walk you through something of the steps of eviction expansion. And so I'll talk a little bit about remaining evictions that are still open under the executive order, because there still are some that are out there. And that also is a good launching point for talking about evictions under the transition statute, because a number of the types of cases that can be filed now were available under the executive order. And then I'll talk about what happens, which cases open up at each of these different dates. Talk a little bit more about financial assistance, looking for housing mediation, and what you can do to help. So resources. I've got my own website, Housing Law in Minnesota, and it is part of a teaching website I have called Poverty Law. I'm just going to toggle over that to a moment. So this is what the Housing Law in Minnesota page looks like. If you Google my name, either Larry or Laurence McDonough in Housing Law, you'll probably find it pretty fast. If you Googled my name and Poverty Law, you'd find this general website fast. If you ever found yourself on the homepage of the website, all you have to do is navigate down to Housing Law. And once you're there, if you want to look at what we're discussing today, the very top link here is the Pandemic Eviction and Other Housing Laws and Rules. And I've got a link there to the transition law and also the executive order. And then this slideshow will be up there later today or tomorrow. The version that I did yesterday, which is actually quite similar, is what's up there right now. I've also got an eviction answer form for people that are assisting tenants. This is a form that basically goes through the different types of defenses, and people can check off boxes. And if anyone's ever working with that form, I'm happy to help them walk through it. I've also got a different answer. So Form A1V2 is for eviction cases under the transition law that are available to be filed up to September 12. And then I've also got A1V1, which is for cases under the executive order. Probably not that many cases left there, But if you do happen to have one of those cases, that's the answer form. And these answer forms also help you work as a checklist if you are representing tenants from a defensive standpoint. If you're representing landlords, it's something you can use from an offensive standpoint to see if you've got your case in order, so that different defenses might not be available to tenants. Okay, Homeline also has a great website. If you hope, maybe you found this training from getting to their website. If you haven't been to their website, there's a lot of really good information up there. Law Help is a great site that's focused more on non-attorneys, a lot of short 2 to 3 page documents about different principles in the law and how they affect people, not just landlord-tenant law, but all types of areas, family law, government benefits, and the like. And the Minnesota State Law Library has a good site as well. Occasionally, I'm going to look off to my left and just make sure I'm on track for the time. I'm not avoiding you guys when I look to the left. Okay, the Eviction Transition Law. I just call it Article 5 of House File 4, but this is the full title of it. And if you download a version of this slideshow, either whether you get it from Homeline or you get it from my website, and if you put your cursor over these links, it'll take you to these documents. So this would take you to the Eviction Transition Law. And the really important part of that law for what we're discussing is not the whole law, it's just Article 5, which is toward the bottom of it. Now, it ended the executive orders and replaced them with a transition law. Now, there is a CDC eviction suspension order that's been in the news a bit. It was in play starting on September 4th, I think, of 2020, and it expired this summer, but then was renewed shortly after its expiration, and it goes until October 3rd. It's in the news a bit because it's national and there's been litigation around it. The Supreme Court's weighed in on a little bit once on its predecessor, but it is in effect right now. Its impact on Minnesota is fairly narrow, and I'll get to that in a few minutes. And if you, whenever you have a copy of this slideshow up, you can click on these links and they would take you to the CDC order and the CDC tenant declarations. Okay, I want to talk a little bit about how evictions work. They're often called by judges and attorneys to be summary proceedings, and that's it can be a little bit misleading. They're only summary in that they move quickly before and after trial. There's not a lot of time before trial, and there's a fairly short appeal period afterwards. There's a fairly short period for enforcing judgments in eviction cases, but the actual trials themselves are not supposed to be treated any differently than other civil trials. Now, there certainly have been some judges and attorneys that have thought they're kind of like conciliation court. They really aren't. Conciliation court is a special court that's really geared for non-attorneys. Some attorneys practice in conciliation court, but for the most part, it's for non-attorneys. Eviction cases are heard in district court, and housing courts are simply a division of district court. And so often the trials are shorter, but all the functions of a trial exist in eviction trials as well. They're governed by a number of different areas of the law. The legislature has a chapter of the Minnesota statutes, 504B, has a lot of different statutes that govern eviction cases, and also just the relationship between landlords and tenants. Like the reason where there are rules on security deposits in terms of how they're handled is because there's a law that's in 504B that sets out the rules for that. But evictions also are covered by the law of contracts. And when I say that, there's a body of law that's been developed by the courts that discuss certain principles of the relationship of parties to contracts. And that's called contract law. And leases are contracts. And even when, sometimes people will say, well, you're a tenant, but do you have a lease? And I get why they're saying that, because they're thinking the lease has to be a document. But the lease can be oral. So there are oral leases and there are written leases. And so any tenant of a landlord has a lease. The lease is the relationship between the landlord and the tenant, also called a tenancy. And a document would be a lease contract or a lease document. But again, you could have that agreement orally. There's also the law of property, and this talks about the relationship so of people to physical property, like the ground and houses, and that plays into landlord tenant law. There are also various types of court rules and also local ordinances in some cities add to the rules of relationships between landlords and tenants. Appearances. This gets at who can represent somebody else in court. Okay, and there are a number of different categories of who can be there and who can't. So to get to the second bullet point there, an individual landlord and an individual tenant can represent themselves. They don't have to have an attorney. An unincorporated business can be represented by someone with a power of authority from that business. Now, when we get into corporations and LLCs and LLPs, they have to be represented by attorneys, except in the housing courts in the 2nd and the 4th districts. And the reason for that exception, it's based on the interpretation of the Court of Appeals of a particular rule. I frankly think the Court of Appeals got it wrong, but they said what they said. But outside the 2nd and 4th districts are Ramsey and Hennepin County. So outside of those counties, corporations, LLCs have to be represented by an attorney. Management agents can represent the owner of the property, but with what I just said in mind. If the owner of the property is a corporation and we're outside of Ramsey and Hennepin County, then the corporation cannot be represented by a management company or an agent. Tenant or landlord may be represented by a person who's not a licensed attorney, except that person cannot conduct a jury trial, and jury trials are pretty rare in eviction cases, can't do appeals, and can't charge or collect a fee for that service. Now, again, with the limitations I discussed above. So if let's say I'm a non-attorney tenant and someone who's not an attorney who knows something about landlord tenant law wants to represent me, they can do it as long as we don't have a jury trial and that person does not charge me a fee. Now, starting March 1 of this year, paralegals and paraprofessionals can appear on behalf of tenants in housing disputes under Chapter 504B. So that includes evictions, lockout cases, and different types of habitability cases, and also expungement motions. Okay, so that's just for tenants, and this is statewide. Now there is an exception for the housing court in the 4th district, which is Hennepin County. So essentially outside of Hennepin County is where this project works. And so this allows paralegals and law firms or in legal aid offices or elsewhere to be able to help out with tenants. Okay, the complaint. The complaint is a document that a landlord files to start an eviction case in the court. And it has to be very specific about what the landlord is alleging is the basis for the eviction case. When I analyze cases, either if I'm assisting a landlord or a tenant, I say the complaint ought to basically kind of have a who, what, when, and where going on. So who did what did they do, when did it happen, and where did it happen are the kinds of facts that ought to be in an eviction case to support the court evicting a tenant. The complaint also needs to have contact information, so how the tenant can reach the landlord physically, not just by phone or by text or by email. There are instructions on eviction complaints at the court's website. There are some standing orders. So what are those? Standing orders are orders that courts issue now and then to discuss how things ought to be handled in the court system. So we have rules of court that say, for instance, what is a hearsay and what isn't. Okay. We also have, but these standing orders are kind of to supplement that. And sometimes it's because of very particular circumstances or particular kinds of cases. So we've had several standing orders in the last year discussing eviction cases in the court system during the pandemic. And all these decisions that I have here were from last year, and some of them talked about eviction cases under the executive order, but some of them also discussed what's going to happen in the period after the executive order, which is where we are right now. for the most part, these decisions are telling landlords that you need to show the courts that you're in compliance with kind of the special pandemic related laws that are in effect at the time. So when the executive order was in effect, making sure that the complaints and the cases were compliant with those executive orders, and now with the transition law compliant with those. You can look at these orders by clicking on the links on the slideshow when you get it, or and also the court has its own website for court orders specific to the pandemic, and there's a drop-down menu there for all the different counties. So you could take a look and see, for instance, is there and are there any special orders in Roseau County that would impact you? Okay, service. This gets at the issue of how landlords tell tenants that they have filed a case. Okay, and it's and the process is getting a copy of the summons. The summons is a document which says when your court hearing is, and the complaint is the document that says this is why this court case has been filed against you. So in the eviction context, it would say there's an eviction hearing coming up at this date and time, and then the complaint would say this is why the landlord thinks the court should evict this tenant. Okay, so there are three types of service. One's called personal service. This is the least regulated type of service. It simply has to be done 7 days before the first hearing in the case. And these are 7 calendar days, not 7 days to the minute. So if I had a court hearing scheduled for next Wednesday at 9 in the morning, I would still have time to get the court papers served on the tenant by later today, because it's calendar days, not minutes. Okay. There are two types of substitute service, and each of them is a little more regulated. The first one is called substitute service on a different person other than the defendant. And so let me give you an example. Let's say that I'm a tenant, or let's say we've got tenant A and tenant B, and I'm the person who's serving the court papers. And I find tenant A at the grocery store, and I give tenant A a copy of the summons and complaint, and we're at least 7 days out from the court hearing, then the service is good. But let's say I give A a second copy, and I say, you live with B, give this to B when you get home. And he says, yeah. Okay. That is not proper service, because when you look at the second bullet point here, for substitute service on somebody else, has to be 7 days before the court hearing, which we had, leaving a copy at the defendant's usual place of abode, in other words, the resident. And so the problem I did is I did that at the grocery store. And so service on A is okay, service on B is not okay. And now the court's going to have to figure out what to do with this. Is the court going to dismiss the whole case? Because it would be a little weird to evict A and not be able to evict B, because then the landlord's really not getting the property back. It's just excluding one person from the property. So the court could dismiss the whole case. The court potentially could let the case go against A and not against B, but it'll kind of put the landlord in kind of an odd situation at the end. Or the court potentially could put the case on hold and tell landlord, you got to get B served again. And once you do that, we'll schedule another court hearing at least 7 days out from that. Okay. Also, the person who receives the court papers has to be of suitable age and discretion. So, example I want to give you there is I have an adult daughter with special needs who's in her late 20s, but she functions more like a preschooler. And if the court papers were delivered to her, she would not be of suitable age and discretion. That would not be proper service. Okay, the third type is called mail and posting, and it has a sequence to it. And the reason this is more regulated is, at least in personal service and in substitute service on another person, at least somebody is getting the court papers. With mail and post service, the court papers are simply showing up somewhere, and there's kind of a hope that the tenant will see and receive those, but it's not necessarily assured. So there are more requirements in place to make sure that the tenant is actually more likely to get it. And so the requirements are, before you can do mail and post service, you have to go out to the property at least 2 different times on 2 different days, and one of those in the evening between 6 and 10. And only if you're unsuccessful in those 2 attempts can the landlord now mail a copy of the summons and complaint to the property, and then come back a third time to the property to post it in a conspicuous place like the door. There's another type of case called expedited eviction. And when I've advised landlords on this in the past, I've generally tried to dissuade them from doing them because the case doesn't go that much faster. You get your first hearing just a little bit faster than you would in a regular eviction case. But look at the second bullet. Your window for doing service is now 24 hours unless the court gives you more time for good cause. Okay. Now, if I'm stuck doing mail and post service, I potentially could do that in 24 hours and get it done, but I'm gonna have to giddy up, right? Because I'd have to do the first service tonight between 6 and 10. And let's say I'm unsuccessful, do the second service tomorrow, maybe sometime in the morning. And then if I'm unsuccessful, then mail the court papers to the tenant, go back to the property a third time, post it, and then file my affidavit of posting, and getting that all done before 24 hours, which would be before 2:01 in the afternoon tomorrow. So again, I don't think landlords get much out of it. I know it might seem kind of attractive because if you think you've got a tenant who's done some really bad things, you ought to be able to move it faster, but it doesn't move that much faster. Even if the tenant's done really bad things, you can still do that in a regular eviction case, and you don't get stuck with this really narrow window. Rachel, do you have a question for me?
Yeah, question came through on the chat, and this is also a good example of I miss things in the chat. So it's better to use the Q&A option if possible, because I missed this one. It's actually back about leases. If you don't mind rewinding just a second.
Sure.
Jen is asking, what about situations where someone is living in another's home temporarily, but there is no exchange of money or services? Is there still an argument that there's an understood oral lease?
Okay. Well, you're kind of getting at the right points, because the definition of a tenant is someone who resides in the property owned by someone else, and they're either paying rent or providing service in lieu of rent, or at least they've agreed to do that. Okay. And so let's say I have a relative staying with me for a couple of weeks, and I'm not asking them to pay rent. I'm not asking them to do anything. I'm just letting them stay here. And now they don't leave. Okay. Then essentially what they are is a trespasser. And if they don't leave, I can call the police and ask them to be arrested as being a trespasser. I could file an eviction case against them as a trespasser, but that would be slower than calling the police. I could change the locks on them, because if they're not entitled to be here, they don't have a right to have access to the property. Now, a lot of times it's a good idea to talk to an attorney if you're unsure of whether someone is a tenant or not. Okay, because if I change the locks on this person and the court ultimately determines that they are a tenant, then I will have illegally locked that person out and be subject to some damages and some penalties about it. So the whole thing about, and so one other thing I want to say about this is, well, let's say I now have this relative staying with me for a couple of months, and I say, and we agreed you're going to pay some rent, and now she's never paid any rent. Okay, so does that make her not a tenant? No, it makes her a tenant, because we agreed that she was going to pay rent, even though she didn't pay rent. So in that situation, I would need to file an eviction case for non-payment of rent. And I'd only be able to do that in limited circumstances right now, which we'll discuss in a few minutes.
Okay, thank you. And then is someone doing dishes in the background over there?
What's that?
Was someone doing dishes in the background over there?
Possibly.
Okay.
Yep. Are you getting a little background noise or not?
We can hear some clanking.
Okay.
So.
Okay. Well, it could be that the dishes make more sense than me. So we'll just have to see how that goes. Maybe we can have a conversation in the chat about, would we rather hear the dishes or would we rather hear Larry?
I would much rather hear you, please.
Okay.
Thank you.
Okay. All right. Okay. One other thing about service is that the courts have said that service has to be done very specifically according to these laws that I just discussed. And so minor deviations from that can lead to a dismissal of the case. So if you're on the tenant side of a case, you need to analyze that and see if service was done properly. If you're on the landlord side of the case, just make sure you do it properly. Now, when cases get dismissed for having service done incorrectly, the term is used, they're dismissed without prejudice, which means that the landlord could refile the same substance of the case and try to get service right the next time, okay? And some people might say, well, what's the benefit in that? You're just kicking the can down the road. In my experience, when cases get dismissed on what we call a procedural ground, which service is one of those, most often that case doesn't get refiled. Usually it leads to a conversation between the landlord and the tenant about how to avoid doing another case. So it's not a waste of time on the tenant's side to get a dismissal without prejudice. And it's certainly a benefit on the landlord side to not get a dismissal with or without prejudice, because that means you've lost your case. If it's with prejudice, you don't get to file this case again. If it's without, you get to file it again, but you're looking at another filing fee and more delay. The courts also look at who delivers the court papers. It can't be the person named as the plaintiff in the case. And some court decisions have extrapolated out from that, that it can't be someone who has essentially a vested interest in the outcome of the case. So when I'm advising landlords, I say, don't use the caretaker, don't use the manager, someone who's collecting the rent, managing repairs and stuff. You run the risk that the case would get dismissed with that person being the wrong person to have served the papers. Okay, a little bit about scheduling. Cases are scheduled within 7 to 14 days of filing, and a little bit faster if it is a expedited case, but as you can see, not much faster. And when cases are then scheduled for a trial, the statute talks to them about being scheduled within 6 days, sometimes a little bit longer. The court decision, the courts really have the power to schedule it as they can. And that's based on a court decision called Rice Park that said the courts have some flexibility regardless of the statutes to schedule cases when they have time to do that. The answer is the response to the complaint. So this is when the tenant would be saying, this is why I disagree with what the landlord said in the complaint. Now, the statute uses the word answer as a verb. So the tenant answers the complaint by saying whether he or she disagrees with the complaint. That can be done orally or in writing. You do it orally at the first hearing in your case. You do it in writing by filing a written document called an answer. Most of attorneys, we end up e-filing that, but people that are representing themselves people that represent themselves are called pro se. So a tenant who's pro se could file that as a paper document at the court desk. But the rub here is that there's a filing fee for it. And it's in the neighborhood of $300. It's a little bit different from one court to the next based on different library fees and court fees that they have, but it's in the neighborhood of $300. Now, if your income is low, whether you're a landlord or a tenant, you can ask to have that fee waived. You file a document that's called an informa pauperis or an IFP document. And I have information on that at this link and also on my website. I've also got answer forms on my website as well that as I mentioned earlier. Okay, we're at around 2:09. I think we're doing okay. So this slide really gets at the fact that these trials and cases are really supposed to be kind of decided and handled just like any other case in the court system. So the plaintiff or the landlord has to prove what they're claiming by what's called a preponderance of the evidence. So they have to be kind of very convincing that what they say is true. So, and where some landlords get into trouble is they say, well, I think this. And the court says, well, you know, if all you do is think that, then maybe that's not enough to prove to me that this actually occurred. So the landlord's got the burden to prove what he or she is claiming in the complaint to the satisfaction of the court. And then the court has to make specific rulings on what the landlord's claiming and what the tenant is saying in defense. There are also a number of different rules that apply. I'm not trying to scare people about these cases, but I want you to know that it's simply not, I mean, I've been a landlord in my life and I know how to fix things, okay? Just because I know how to fix things doesn't mean that I know how to handle a trial in a court. And so if you are going to represent yourself pro se, it's good to get a little bit of advice from an attorney on how to do that so that you can navigate what you need to prove, whether you're the tenant or the landlord, how the rules of evidence work, the rules of civil procedure, housing court rules, what is a hearsay, and there are exceptions to the hearsay rule, so when do they apply? And also, when can people talk about what they see versus their opinions? Do you have another question, Rachel?
Yeah, actually, Emily from they're a landlord. They're asking if you plan on sending a non-renewal for lease violations such as property damage and beyond poor housekeeping, would you recommend including the reasoning in the paperwork sent? Not normally something we do, but with the reasoning requirements, is this helpful? And I think with the proof and findings, that's a nice tie-in in general.
Yeah, and this gets at what some of what we're going to talk about under the transition law. So before the pandemic, if you wanted to not renew the lease, you actually didn't have to send a letter. You could just, when the lease is done, it's done. And I think it's a good idea to send her a letter, or at least have a conversation with the tenant saying the lease is up at the end of August, and just seeing if that tenant agrees that he or she's going to move. And then if that person didn't move, you could simply file a case saying this lease expired and the tenant didn't move and doesn't have the right to be there anymore. I want to have possession of the property back. So you wouldn't have to have any reason for doing that. Okay. But where we are right now in the eviction transition law, you would have to have a reason for doing that. You'd have to either, and we'll talk about those reasons in a few minutes. So if you want to not renew a lease right now, going up until mid-October, you ought to have a reason for it, and that reason should conform with the types of eviction cases you can file right now. And if it doesn't, that termination isn't going to be proper, and any eviction case that you would base on it you would probably lose. Okay, any other questions for right now, or should I keep rambling away?
Please keep rambling on.
Okay, we're going to ramble on. Okay, so precondition issues, what are those? These are some issues that landlords need to get right before they file cases, and tenants can sometimes use as a defense if they don't. So one is the plaintiff has to be the person or entity that's entitled to possession of the property. And that may seem kind of obvious, but if you're a landlord and you're ABC Properties, then don't call yourself on the court papers ABC Rental, because then maybe there is no ABC Rental, and ABC Rental doesn't have the right to file a case. Also be consistent. Use the same name on the lease with the property tax people, with the licensing people, with the Secretary of State. On the defense side, if you see a number of different players here with saying they're different entities to different places, you've got an argument that the plaintiff is going to have to prove that the one who filed this case is actually the right one. If someone is filing a case on behalf of somebody else or something else, they should have a power of authority and showing that relationship. Again, we talked a little bit about address disclosure, and at the bottom of the slide, we talked a little bit about making sure there are enough facts in the complaint. Also, this second to the bottom bullet point here, businesses that are using a trade name other than a real person's name have to register that with the Secretary of State, whether they are a corporation or not. So let's say, so I'm Lawrence McDonough. Let's say I have a business called LM Properties. I never incorporated it, but it's still a business and it doesn't reflect my name. If I were to file any kind of case, including an eviction case, and the defendant figured out I hadn't filed with the Secretary of State, they would be able to ask the case be put on hold and get $250 as a penalty for me for not having registered. Okay, so now we're going to talk a little bit about Executive Order 2079. You might be thinking, well, why talk about that if it went out of effect on June 30th? Well, there are two reasons. One, if for any case that's still in the court system that was filed under Executive Order 2079, that's the law that applies to the case, because that was a law that was in effect at the time the case was filed. So for the purposes of the way lawsuits work is you look at the state of the law at the time the case was filed to figure out how the case ought to be resolved. Now, the other reason is that there are a lot of common elements between Executive Order 2079 and the transition law right now. And so it's good so we can talk about those provisions, and I've got links to court decisions that kind of flesh out those things. So what could be filed under Executive Order 2079? Basically, non-payment of rent cases, none of those could be filed. What could be filed were cases claiming tenants seriously endangering the safety of other residents, violating 504B171. And a lot of people think 171 only deals with drugs. As you can see here, it deals with drugs, prostitution, unlawful use of firearms, stolen property by robbery, domestic abuse, criminal sexual conduct, and harassment that happens on the property. So a really broad kind of category of different types of crimes and unlawful activities. Now also, a material violation of a residential lease by seriously endangering the safety of others or significantly damaging the property. Now, I heard a number of times, in the last year and a half, people saying, I've got the tenant from hell and I can't do anything about it. And I think those folks were either misinformed by somebody else or were intentionally misforming others. Because as you can see from this list, if you had a tenant, for instance, harassing behavior is a fairly broad category of conduct. So you look at things like drugs, prostitution, firearms, stolen property, we've harassment, we've got all the, and seriously endangering the safety of others. That could be threatening violence or committing violence. Significantly damaging property is essentially kind of violence act to property. I just don't buy that someone could not have evicted a tenant who was doing really nasty stuff. Okay. All of these things that I just mentioned are parts of the eviction transition law right now as well. Now, the next one, termination of the lease, so that the owner or owner's family member could move into the property. That was just under the executive order. It's no longer an element of our transition law right now. That could only be done with a lease termination notice. And in all eviction cases, landlords had to give a notice of intention to file the eviction case at least 7 days before the hearing to give the tenant notice that a case is coming down the pike if you don't get things resolved with the landlord. Okay, so when analyzing these cases, again, and I'll kind of go back a little bit now and then, say, always remember, you got to have the procedure right, your service right, and precondition right. If you're on the tenant side, you need to be looking at those things to see if they were done correctly or not. So let's talk a little bit about what types of notices were required under Executive Order 2079. Well, some of them were, so two types of notices. Lease termination notice, and this is not for all cases. This would only be when the landlord was trying to use the family residency basis, but also cases of covered properties under the CARES Act. So what's the CARES Act? That was a law that was in effect last summer for the most part, but some of it's still around. It's what set up the early unemployment compensation supplemental benefits. There was an eviction moratorium that was in play for part of the summer before the CDC did its moratorium in the fall. But one provision that did not expire was one that said for covered properties, landlord would have to give a 30-day notice before filing an eviction case, any kind of an eviction case. So what are covered properties? Well, it's public and subsidized housing, kind of the whole alphabet soup of the different subsidized housing programs, but also federally backed mortgages. Okay? So if I'm on the landlord side, I want to figure out if I'm a covered property. Now, if I'm not in public or subsidized housing, I'll probably know if I've got that, but I might not know if I've got a federally backed mortgage. So I live in a home here in St. Paul. That's my piano in the background. I own this house. I'm not a landlord presently, so I don't really need to know if I have a federally backed mortgage. But if I had to know, I'd have to go figure it out because I honestly can't remember because my mortgage, I've been here for about 15 years. The mortgage has moved around a few times. So if you're on the landlord side, you want to figure out whether you are or not a covered property. And if you are, give the 30-day notice. If you're on the tenant side, you want to figure out if it is a covered act property to see if the landlord should have given a 30-day notice when maybe they didn't. Okay, now there are notice requirements that predate the pandemic, and those are still in effect. for manufactured home parks, mobile home parks, and also for terminations of tenancies. So let's say, well, I mean, for mortgage foreclosure and contract for deed cancellation, there's a statute that says that once the mortgage is foreclosed, if there was a tenant of the homeowner and now the bank owns that home, the bank has some notice requirements to that tenant. And these pre-existing notice requirements from before the pandemic are still in effect. Then we also had the notice of intention to file the eviction case. So in some cases, landlords would have to give 2 different notices, some cases only 1 notice. Now, there are some defenses that apply to any case where a notice is given, if the facts are right. And those include retaliation and waiver if the landlord accepted rent after the effective date of a notice. Okay, so let's talk a little bit about some of these substantive claims. So 504B171. So again, the landlord's got to prove the case. And the key word here in the statute is allow. Is the tenant allowing the different things that are listed in the statute to happen? And so simply because something happened, if it was done by somebody other than the tenant, doesn't necessarily mean the tenant allowed it. And so consistent with that, there's a defense that, for instance, with drugs, that the tenant didn't know or have reason to know that there was unlawful activity in the property. Another is a tenant couldn't prevent illegal drugs from being brought onto the property. So when would these things happen? Well, maybe for the first one, maybe the 15-year-old kid has drugs on property and mom doesn't know about it. On the second one, maybe A is a domestic abuse victim of B. A lives in the property, B doesn't, but B comes to the property. A can't keep B out, and B brings drugs out of the property. Also, medical marijuana is legal in Minnesota, so therefore its use would not be unlawful. And again, in all these slides here, I've got links to a couple different manuals that I have that discuss the cases that apply these different principles. So you could go to these and say, okay, well, what was going on with this case where the caretaker smelled some marijuana but couldn't really figure out which apartment it was? And well, in that decision, that case, the landlord lost because they couldn't really, there wasn't enough proof there that the tenant was the source of the smell. Okay, for significant damage cases, I think the key word there is really significant. Just because there's a damage doesn't mean it's significant. With serious endangerment, really focusing on, is someone really threatened, and are they threatened with something serious? So maybe just swearing at someone isn't threatening, but saying I'm going to get you, implying that I'm going to hurt you, may very well be seriously endangering. I think there was one serious endangerment case involving a dog that was maybe biting or scaring other people. Okay, for landlord family residency, again, you had to give proper notice and had to prove kind of the need to use that specific unit. So what are some defenses that tenants can raise when there are cases focused on the tenant's conduct? Okay, well, one is that it's not that big of a case. It's not a material breach. We'll talk about what materiality means in a few minutes, and it's actually a fairly high bar of what a landlord has to prove a breach of lease case. Leases also have to have a clause, a right of reentry clause that says the landlord can evict if there is a breach. So sometimes where landlords run into problems, if they have an oral lease and all they agreed is that the rent's going to be paid, now they want to evict for being too loud. Well, first of all, I'm not sure if too loud would be a material violation. We'll talk about in a few minutes. But one, the lease doesn't have any provision about not being too loud, and their oral agreement doesn't have the agreement that I can evict you if you're too loud. So generally, landlords are better protected by having a written lease that kind of lays out what they want to happen or not happen, and to be able to evict for things that are not in compliance with the lease. Okay, landlords can waive lease provisions by not enforcing them or by accepting rent with knowledge of violations of the lease. Tenants with disabilities can sometimes get the court to order the landlord to reasonably accommodate their disability. Doesn't mean the tenant gets kind of the ability to act as they wish, but tenants with disabilities get cut a little bit of slack if their disability is getting in the way of them complying with the lease. Landlords can't penalize tenants for calling the police or emergency assistance. Victims of domestic violence have some special protections. Retaliation can be an issue in eviction cases. And this forfeiture principle, courts actually have the power to let the tenant stay even when there has been a lease violation, but only if the landlord's rights are being adequately protected. And there are some special rules for manufactured home parks and public and subsidized housing. So what kind of things can the court do in an eviction case? It can enter judgment for the plaintiff or the defendant. Entry of judgment means if you enter judgment for the defendant means the defendant won. If it's for the plaintiff won. If the plaintiff filed an expedited case and did that improperly, the court can fine the landlord $500. That's another reason to be very cautious about doing an expedited case. If the tenant loses, the tenant can ask for 7 days to move. If they have a hardship, the court can award costs and disbursements to the winner. Costs and disbursements are like if you paid a filing fee, the court can order the other side to pay you back. If you have some out-of-pocket costs, like paying for an expert or something, you could ask the court to have the other side pay you. Generally, you don't get paid for having to take time off work or having to take time to drive to court or something like that. The court can expunge the file if under certain circumstances, in other words, make it non-public. And the court can award attorney's fees if there's an attorney's fee provision in the lease. And if there's an attorney's fee provision in the lease that benefits the landlord, a law that Homeline and I helped get passed back in 2010 makes that reciprocal to tenants as well. So if the tenant wins the case and there's an attorney fee provision in the lease, the landlord might have to pay attorney's fees to the attorney representing the tenant. Okay, now let's get to what happened on June 30th. On June 30th is when the transition law went into place. And so then we had kind of a new set of grounds for eviction cases. And you can see there's a bit of similarity here. Okay, we've got serious endangerment, significant property damage, 504B171. The manufactured home park provisions are pretty similar to what was available under the executive order. So what's different? Well, one thing that's different is there now is a non-payment of rent claim that wasn't available under the executive order, only if the tenant is eligible for state emergency rental assistance and refuses to apply or provide information to the landlord or refuses to provide proof to the landlord that the tenant applied. That's the only type of non-payment of rent case that can be filed right now. Landlord could also file claiming the tenant abandoned the property. And this highlighted section I'm going to say several times because I want to really hammer this point home. Landlords cannot file for non-payment of rent against tenants with a pending application for emergency rental assistance. Okay. Now, so a pending application for state assistance protects tenant from a non-payment of rent eviction case. It does not protect a tenant from any of these other grounds above. Okay, so doesn't give the tenant the ability to seriously endanger, significantly damage property, violate 171. Okay. Only the non-payment of rent eviction case is blocked by having a pending application. So when you're analyzing eviction cases as of June 30th, again, you got to remember to look at procedure, service, and preconditions. The notices are a little different now because we no longer have the family residency ground and its notice requirement. Okay, so and we also don't have the notice requirement of the intent to file an eviction case. So a landlord, if they filed a family residency case on June 29, that would be analyzed under Executive Order 2079. If they filed that case on June 30, it should be dismissed because that's not an available ground under the transition law. The new notice was a notice for non-payment of rent. It's a 15-day notice, has to say that the moratorium's over, you might be evicted, this is the total rent due, and you can apply for assistance with Rent Help Minnesota. Now, as with other notices, remember that landlords can waive notices and retaliation can be a defense to notice. So I have several references here that even though we're now talking about the transition law, there are earlier slides that are relevant to what we're discussing right now. Do you have another question, Rachel?
Well, we've got several questions that relate specifically to the transition language and things that landlords can do and things like that. So I wanted to step in here and see if that was something that you wanted to get into now, if this was a good time, or if you wanted to wait till later at the end. I know that we're going to be moving into slightly different territory in the next slide.
why don't we wait until we get to the July 14th slides and then go into it?
All right.
Because
sounds good.
then we'll be talking about where we sit right now. Okay, so with the substantive claims that are available as of June 30th, again, the family residency ground no longer available. And for manufactured home parks, kind of have to look at the law and see if the conduct that's being alleged fits those statutes. With the issue of whether the tenant has abandoned the property, this hadn't been a common ground for eviction cases in the past. Usually if the landlord wasn't sure if the tenant abandoned, they filed an eviction case. If they were pretty sure they abandoned the property, then they would just change the locks and re-rent. So we don't have a lot of experience with eviction cases based on abandonment, but we do have experience with what are called lockout cases based on abandonment. So that's where the landlord changed the locks and tenant said, wait a minute, I still live here. And the landlord said, no, you abandoned the property. And the tenant says, no, I didn't. And the court has to figure out, did they abandon or not? Just because the tenant is gone for a while doesn't mean they abandoned. And so if I were on the landlord side, I'd be very careful about filing an eviction case or changing the locks based on abandonment. But certainly if you're unsure, don't change the locks. And if you're unsure, maybe you file the eviction case, but then you got to prove abandonment, just not the tenant being gone. And so the other new claim that we have are the non-payment of rent claim. And again, those claims have to be dismissed if the tenant has a pending rental assistance application. So if the landlord wants to do a non-payment rent claim, they have to prove, one, the tenant's eligible, and two, they refused to apply, refused to provide information to the landlord, or refused to provide proof to the landlord. So what are some of the defenses? Well, one defense is that the tenant is ineligible for state emergency assistance, okay? That my income is too high to be eligible, or that I did not refuse. Refuse not applying is not the same as refusing to apply. Refuse is essentially an intentional kind of non-act as opposed to kind of an unintentional non-act, okay? The landlord would have to prove that there's refusing. Now, something the tenant could do to maybe help prove that they are applying would be the CDC has an eviction protection declaration. This is one of the areas where I think the CDC executive order might have some intersection here, because there's a declaration a tenant can file saying this is what I'm doing to try to apply. And so that might help counteract the claim that the tenant's refusing to apply. And one other area where the CDC order might have some impact here, and we'll just have to see what the courts say about it, is tenants who use their best efforts to obtain all available government assistance for rent or housing are protected under the CDC order. That's broader than just applying for state rental assistance. So we'll have to see what the courts say about whether the CDC order applies in Minnesota. If it does, tenants that are at least trying to get assistance, even if they haven't applied for state rental assistance, might have protection from eviction. And I can't really give you the answer on that because we don't have any court decisions on it yet. Some other defenses that apply pre-pandemic to any non-payment of rent case that would apply here as well, if the facts are right, is if the landlord's not maintaining the property in good condition, landlord's not complying with city rental licensing ordinances, if the landlord's not complying with our statutes on how utilities are managed and charged, if we have improper late fees, if the landlord's accepting partial payments of rent, if the landlord's retaliating. These are all things that could be raised in defense of a non-payment of rent eviction case if the facts support those. Now, I do want to mention the concept of redemption here, because I think this has been misunderstood in the past. Redemption is the court saying to me, McDonough, you owe $1,000 in rent. You have to pay it right now. And if you don't, I'm going to evict you. So then my redemption period is essentially immediate. Okay. Now the court, a lot of courts will say, okay, McDonough, I'll give you 7 days for that. Okay, because that's the most I can give you. Okay. And that's where the misperception is. There's no statute or case that limits the amount of time or the conditions the court can consider in putting a deadline for redemption. In the 614 case, the court gave a commercial tenant 1 month to pay what they owe. So I think, too often I think some courts and some attorneys have, where they get that 7 days is remember I mentioned earlier that if a tenant loses and wants some extra time to move for hardship, the tenant can ask for 7 days. But that's simply more time to move. There's nothing in the laws or the court decisions that say that that deadline applies to asking for time to pay. So the court would have that ability to say, okay, McDonough, I'm going to give you 3 weeks to pay. Or McDonough, you've convinced me that your rent's $1,000 and you owe $1,000 and you can only pay $500 on top of your $1,000 this month and next month. So I'm going to give you 2 months to pay it. You're going to have to pay $500 this month on top of your rent, $500 next month. So if you're a judge or referee, hearing this presentation, take a look at the 614 case. You are not limited. If you're representing a tenant, be creative and ask for the amount of time you think would take to resolve the problem. Now, I'm not saying that the courts are going to give you 6 months to pay, but I think courts are well within their authority to go beyond this notion of 7 days. Okay, now what happened on July 14th? One new area opened up, and this is kind of the area where we sit right now in terms of filing cases. Now, Rachel had mentioned that a new area of lease terminations opened up on August 13th, but eviction cases can't be filed on that until we get into the second week of September. And I'm just talking about what can be filed right now. What can be filed right now, in addition to all the other categories, is a material lease violation. So that's the new category as of July 14. Okay, so what does that involve? And this is also another area where there's been some misperception by attorneys and landlords and some judges, is the bar is actually pretty high here. What the appellate cases say about this, and I just want to read this to kind of reinforce the point. Material breach goes to the root or essence of the contract, so substantial and fundamental that it defeats the object of the parties in entering into the contract, and where the injury is irreparable or damages would be inadequate or difficult or impossible to determine. Now, why would the standard be that high? Well, the reason for that is if I have a 1-year lease with my landlord and I'm on month 3 of it, and the landlord wants to evict me for a material breach, we're essentially kind of ending my ability to possess the property, where both of us intended me to possess it for a year. And so the courts have set the standard high so that it's not a common occurrence that any old violation would lead to me being evicted from the property. So if you're on the landlord side, you need to really convince the court that this is a big deal and not a little deal. And if you're on the tenant side, you try to convince the court that it's a little deal. Okay, so is there a list of what is and what isn't? No, there isn't a list. It's very fact specific. So let me give you an example. Let's say we got the loud party. The loud party is the case. Well, in the first example, the loud party is, I have loud parties every other night. They go till 2 in the morning. They're really loud. The neighbors get crabby. They've been calling the police. I've been cited a few times for noise, and the neighbors are threatening to move. I think we probably have a material breach there. Okay. Now, example B. I had one family gathering. The lease says quiet time at 10. It rolled into 10:30. I have a sensitive neighbor. He calls the police come out. They say no big deal. Nobody's threatening to move. I would say that's probably not a material breach. So there isn't a list. It's a very fact specific. And if you're on the landlord or the tenant side, focus on this language to either prove that a breach is material or that it isn't. Okay, so at this point, Rachel, if you've got some questions about kind of do's and don'ts right now, why don't I jump into those?
I do. All right. So we've got several. I'm going to start with some of the pre-submitted questions we got during registration. Glum is a landlord, and they're asking, if a tenant is refusing to apply and the tenant is on a month-to-month lease, what options does a landlord have right now? We have quite a few questions about how can you tell if someone is refusing to apply and things like that. So,
right, and that's challenging. Okay, now this person is saying the tenant's refusing to apply. That's different than actual being able to prove that the tenant refused. And so now if the landlord says, I asked the tenant, and the tenant says, I'm refusing to apply, now you have that person's statement, okay? And so if that tenant denies that, then it might be kind of a he said, she said. If you have a witness to that statement, then maybe you're able to prove that. Now, the person also has to be eligible. So let's say I'm above the eligibility guidelines and I'm refusing to apply because I know I'm ineligible. Then you can't evict me right now for non-payment of rent. You can only evict me for non-payment of rent if I'm eligible for assistance and I refuse to apply. So, you know, this concept of refusal is kind of new to landlord-tenant law. It's more, the word has been interpreted more in the area of consumer law. And maybe one of the things I'll do in the next month is read some of those cases there and see what I can get out of there in terms of proving when someone's refusing or not. So, you know, on the landlord side of the equation, I'd be cautious about going down this road for a non-payment of rent case, because you got to prove one, eligibility. And, you know, when I was a landlord, I did not have monthly information on my tenants' income and expenses and stuff. I had that when I rented to them. Outside of subsidized and public housing, it's really uncommon for landlords to have current information on the finances of their tenants. So one, you may not know if they're eligible. And two, I think proving refusal is going to be hard. I know some landlords are sending out questionnaires to tenants saying, have you applied? The fact that the tenant has not responded to that is not proof of refusal. It's just proof they didn't respond. So if I were a landlord, I'd be cautious going down that road. Now, if you have, you know, a material breach, or you've got 504B171 or serious endangerment or significant damage, it's irrelevant whether they have applied or refused to apply. But one thing to keep in mind here is that if someone is applying, whether, let's say they haven't applied yet, but they're going to apply, or they already applied, and let's say they owe you $1,000. If you do evict them for any reason, you know, you win your case, you're not going to get that money because their application is going to get denied and you're going to be out that. And so I think landlords need to be thoughtful about what's in my best interest. Filing this possibly successful case for material breach and losing whatever money the tenant's applying for going backwards, and they can apply a little bit forward as well. Or is it better to try to work something out with the tenant so that maybe the tenant changes some conduct, maybe I slacken my rules a little bit, allows that person to stay so that their assistance gets granted and I get paid. Now, I'm not saying that if you've got a really nasty situation, if you've got someone who's really violent and scaring people and tearing up the property, it may be a thoughtful decision to say, I'm willing to let go of that possible payment of rent because I need to deal with something related to safety. But that's the decision framework you need to make right now, is what's in my best interest as a landlord.
So Gina is wondering, kind of in that realm, if a tenant has applied but is refusing to complete the application, what do you think that would be? Would that fall under or rise the level of refusal, or?
Well, again, the question is stated as a refusal, and I don't know if the person actually knows that that's a refusal or not. Mm-hmm. But I think having started the application and refusing to complete it, and actually refusing to do that as opposed to not doing it, I think would be grounds for that non-payment of rent case.
And then just to make perfectly clear, if a landlord evicts a tenant due to a material breach, they are not eligible to get the past due rent owed to them from Rent Help MN. But that doesn't prevent them from trying to reclaim it through, say, like conciliation court, correct?
Correct. And so, yeah, whenever anybody owes anybody else something, whether it's landlord, tenants, or anybody else, the person who's owed the money can sue. If the amount is under $15,000, they can sue in conciliation court. Keep in mind, conciliation court is still something of a lower priority for the court system with all the other cases that kind of got thrown off their legs during the pandemic, including evictions. And so last I heard, conciliation court cases being filed in Hennepin County were being scheduled in January. So if you're filing a case, if you're thinking, well, I'll evict this person and I'm going to go after him for the money in conciliation court afterwards, first of all, you need to be able to think about, just because you sue them doesn't mean you're going to get the money. I mean, file the case now and you get your hearing in January, maybe you win that case and then you get a judgment. And then you have to find wherever the tenant may be at that point. And then the issue would be, what's their economy like for that tenant? If that person's on a minimum wage income or less, you're not going to be able to get any of their wages. If they're affluent, maybe. But for people that are really low income, your ability to collect on that may be limited. Now, you still get a judgment that'd be good for 10 years, but I don't know a lot of people that really kind of keep track of the whereabouts and the economy of someone 10 years down the road after they've sued them. So, you certainly run the risk that if you're going down that eviction case for non-payment of rent, you go down that eviction case for material breach. If you win it, you're not going to get the state assistance. It's possible the rules for state assistance might change at some point, but where they are right now, you're not going to get that state assistance. And, you have to think thoughtfully about, if I sued this person, would I really be able to collect on them?
All right. And then there's one more that is relevant, though it's pretty detail specific. So it might be too specific for this particular circumstances, but someone anonymous is saying that they just purchased a duplex, and the seller provided one lease and stated that the second tenant in the duplex, they couldn't find their lease, but that the landlord had used this standard lease for both tenants. One tenant is moving out, but the second tenant, whose lease can't be found, of course, hasn't paid the previous owner for over a year. They're uncooperative in signing a new lease with the new owner or applying for rent help MN. They've left faucets on and racked up about a $600 water bill in the last month. So the landlord is asking, this tenant has a lot of lease violations, if that particular lease does apply to them.
You'd have to prove that lease, the provisions of that applied. And you can have a case based on an oral description of a document if both people agree what the document was, even though you don't have the document. So for instance, if Rachel and I had a contract that said that Rachel's going to go to the grocery store every Tuesday and get groceries for me because I'm not able to leave the house. And neither of us can find that a contract, but we have a case over it and we both agree that the contract existed. Then the case can then proceed based on enforcement of that contract. Now, if one side's saying we had this lease and the other didn't, then the court's going to have to figure out who's more believable on whether that contract exists. And if the court decides that the contract didn't exist or wasn't convinced that it was, then you don't have any of those provisions on which to base the contract. Now, I think as the landlord here, you should talk to an attorney about kind of whether it makes sense to go ahead with this case right now or not. You potentially got the non-payment of rent case, but you'd have to prove eligibility and refusal to apply if you wanted to go down that road. As the facts don't really tell me that we've got significant property damage, we've got a high water bill, but doesn't sound like anything wrecked the pipes. So I don't hear that. I don't hear serious endangerment. And again, without having being able to prove an agreement of the parties, I think you'd have difficulty with a material breach. So I certainly wouldn't do this pro se. If I were you, I would consult with an attorney and really figure out if you think you can fit into one of these. You have to fit into one of these silos that's available under, as of July 14. If you can't fit your case into one of those silos, you're going to lose.
Actually, that's an excellent transition to one last question that just came in about serious endangerment from Anonymous, who's asking, does the serious endangerment language that was in the EO that is carried over create a new basis for eviction, even if the lease doesn't talk about serious endangerment as a lease violation?
Yes. So under the executive order, there was language in there that said nothing in the executive order created new claims for eviction. I believe that the transition law does not have a similar provision. So I think this does create a separate basis for eviction, regardless of whether you have an endangerment provision in the lease or not.
Perfect. Okay, I think that's it for the specific ones for July 14th. We'll have a couple for the September 13th, I think, as
Okay.
well.
Okay, and I will get through the next few slides pretty quickly because we're down to about 9 minutes left. So what opens up on September 12th are the same thing that opened up on October 13th for lease terminations opens up for eviction cases on September 12th. That means landlords can file a non-payment of rent eviction for those ineligible for state emergency rental assistance. Okay, and then we've got all the other, so this just layers on top of what we already had. Okay, so when you're analyzing these cases, think about all the things we've discussed earlier. So the new claim we have, got non-payment of rent. So on the landlord side, the landlord had to prove that the tenant's ineligible for state emergency rental assistance. Now, if the tenant's been denied, maybe that is the proof of that, okay? But keep in mind, the CDC, what I talked about earlier, has a provision that says that the tenants using best efforts to obtain all available governmental assistance might be protected. So let's say the tenant is denied state emergency assistance and is applying for other types of assistance. Beyond that, it's possible that the court would decide that the CDC eviction suspension order basically kind of trumps our law and comes into effect. So we'll just have to see what the courts have to say about that. It's kind of a gray area at the moment. And then, of course, with any other non-payment of rent claim, you've got the different non-payment of rent defenses that we discussed earlier. Okay. Then on October 12th, as Rachel was mentioning earlier when we were looking at her great table, that things mostly get back to normal with one exception, that landlords still cannot file non-payment of rent eviction cases against tenants that have a pending state rental assistance application, and that goes until June 1. So let me give you an example. I think someone mentioned earlier, if I terminate a lease, do I need to say why I'm doing that? Okay, well, right now, yeah, because you'd have to terminate the lease, but then you'd also have to fit into one of the grounds for evictions that are available right now. But when we get to October 12th, we'll really be kind of like pre-pandemic, because back then, if the lease expired and the tenant didn't move, you didn't have to give any kind of notice and you didn't have to have any reason. And so that will be available as of October 12th. So not available before that. And so we're really kind of back to where we were pre-pandemic, with the exception, no non-payment of rent eviction cases for tenants with a pending state rental assistance application. Now, I want to talk a little bit about financial assistance. I think I'll just go through this fairly quickly because we had a slide earlier on it. One thing I want to note here is the Housing Justice Center has a nice slideshow on navigating the application process for state emergency assistance. And they also have a program to help tenants that are having problems with it, and for tenants that want to appeal their denials or do new applications. Got the phone number on this slide. Already talked about the Zero Balance Project. Tenants can apply for back utilities with Rent Help Minnesota. They can also apply with the State Emergency Assistance Program or Energy Assistance Program, and the Citizens Utility Board can help people with that. There are other types of financial assistance out there, like just regular old emergency assistance. So how do you weigh these two? Well, emergency assistance isn't going to pay a year's worth of back rent, because they focus on what's the least amount we can spend kind of keep this person housed. And so it might be, I'm going to pay for a deposit and a first month's rent on a new place because that's a lot cheaper than paying a year's back rent. So state rental assistance is really geared toward paying that lengthy amount of back rent. So tenants should really focus their efforts there if they want to pay off that rent and stay. For a tenant who's looking at needing to move, either because they lost a material violation case, or they lost any of these eviction cases, or they just need to move for some other reason, then Rent Help Minnesota isn't really going to be the source that can help, but emergency assistance through the county would be the way to go. For tenants that are looking for housing, Housing Link is a great resource. I can't think of a better time to be working with mediators when we're in this kind of transition period that's going to be unlike pre-pandemic, and we're going to be in it for another 10 months. Got a link there to get to the mediation program that's closest to you. There are a lot of legal aid programs around the state, volunteer programs that help out tenants. There's also advice online and by phone. There are advocacy organizations that are working on the types of laws that we've been discussing today, both statewide and nationally. And if you have opinions on what's going on, make your voice heard, whether you like what's going on or don't. I've got links here to Minnesota government officials, the legislature, local government, the courts, and the national government. So I'm going to turn this back over to Rachel and Eric, unless there are some questions you want me to try to answer right now. We only got about 4 minutes left.
Yeah, just a couple of really quick questions, actually. So first off, do you think landlords will file evictions for breach of lease as a pretext for non-payments?
It's certainly possible. I think most landlords and tenants try to do a good job, try to follow the law. Sometimes they're a little confused about what the law is. But I think there always have been bad tenants, and there always been bad landlords, and there always has been a subset of the population that wants to get what they want, whether they're really entitled to get that or not. And so we certainly might see some cases where a landlord tries to allege that the molehill is really the mountain, for anyone who gets that nice dated reference. If someone tries to make the loud party that I mentioned earlier that wasn't very big into something that's big, ultimately the court's going to have to figure out, is it big or small? So I think we might see a little bit of that. I would encourage landlords that are unsure whether they've got a strong case or not to talk to an attorney and figure out if they do.
Okay. Emily would like to know if someone is caught up on their rent payments and their lease is ending on August 31st, do they have to leave, or are the protections still in place? And when can a landlord give a valid notice to not renew?
Right. So if the tenant is caught up on the rent, and let's assume that there are no other kind of bad things going on like drugs and endangerment, all that kind of stuff. So then the tenant basically can't be evicted until we get to that final reopening. Okay, until let me just go back to what opens up. Until we get back to October 12th. That's when a landlord would be able to say, you have to leave now because our lease has expired. So I think that the earliest a landlord could give, let's say it's a month-to-month tenancy, I think the earliest a landlord could give a notice to terminate that month-to-month tenancy without fitting into one of the silos that are available earlier would be October 12th. And that would be a notice that would be effective to move out at the end of November. For a lease that expired, let's say the lease expired August 31, the landlord can't make the tenant leave on September 1, can't make them leave on October 1, could say on October 12, you didn't move out. And if you don't move out, I'm going to file an eviction case based on the expiration of that lease in August. But they might run into a problem with that, because if you continue to pay that rent, you've now converted that one-year lease into a month-to-month lease, which means that as of October 12th, you would be halfway through that month and the land. So I think most likely what you'd be looking at, I'm doing this a little bit stream of consciousness, is that the landlord could give you a notice on October 12th to say, I want you to move out at the end of November. And if you don't, I'm going to file a case against you in December.
That's basically what we've been saying as well for that sort of thing. It is 3 o'clock by my clock. So we had a couple more questions come in, but I also want to be respectful of your time.
Okay, so should we just go through the last quick few slides? Do you want to say anything about those, or should I do that?
Yeah, you can just bounce through the next few. They're somewhat repetitive, but thank you, Larry. I think that's again the phase out timeline that we had, just in case there are any other questions about it. I think, Larry, you did put your contact information on one of the slides. We will put the recording from today up on our website, and a link to Larry's website, as well as the slides for today that have some of that contact information, as well as some of the key links and resources that Larry discussed today. So again, thanks a ton, Larry, for your presentation today. And I did just put, excuse me, I did just put in the chat the links to the registration for our next couple sessions, which again are next Wednesday with Assistant Attorney General Catherine Kelly. We'll be discussing their enforcement of the executive order during that time from March last year until the end of June this year, as well as kind of looking forward for them. And then again, we're skipping September 1st and having an evening multilingual session on the 8th, Wednesday the 8th in the evening, and the links are in the chat. So again, thanks, thank you, Rachel, for fielding and asking questions, and Larry, thank you for your very extremely detailed presentation, and folks for joining us. We'll call that a day.
Thanks
Thanks,
all.
everybody.
Thanks.